Hey guys, welcome back to today's video. Today we've got a male Karen with serious anger issues who felt disrespected by some bike riders while driving his truck. So instead of handling it like a normal person, he decided to run them over and then act like he's the victim in court. Originally, the court gave him a huge break because of his medical conditions and placed him on probation instead of sending him to jail. But he completely ruined that chance by ignoring court orders, violating probation, and even threatening court staff and probation officers. Before we start, quick heads up, I'm a bit under the weather today, so there may be less commentary than usual, but this case is still insane. Let's get into it.
Mr. Galt, if you can have a seat there, please. We'll go on the record. This is People versus Richard Galt, file number 244943. The record should reflect Mr. Galt's presence here in the courtroom today, so I can have counsel put your appearances on.
Thank you, Honorable Gurmurthy, on behalf of Mr. Galt.
We're here today. Mr. Gurmurthy has filed a motion to withdraw as Mr. Galt's attorney. I guess one thing that affects the court's consideration here, I want to make sure the record is clear. Again, because I think there's a difference between Mr. Galt, you asking the court to appoint a different attorney for you, and Mr. Gurmurthy asking to withdraw from the case. So I want to make sure that we're clear on the record which of those two I'm dealing with.
Well, I'm going to ask that I withdraw from the matter. I think the other issue, which, and I'll leave it to the court's discretion. Mr. Galt is requesting another counsel. There's a process to that because the court no longer appoints counsel. Mr. Galt has been made aware of that. Mr. Galt has been made aware of that by Mr. Thompson, who is the indigent defense counsel.
Actually, before we go further, Mr. Thompson is, let me bring him in.
Okay, right. And I was just going to say Mr. Thompson wanted to attend this hearing as well.
Your Honor, I've filed several motions
Okay.
to the courts.
Okay, and we'll talk about that in just a second. Mr. Thompson, are you able to hear me okay?
I can hear you, thank you.
All right, we just got started with the hearing involving Mr. Galt. I asked for a clarification as to whether or not Mr. Galt was asking for different appointed counsel or whether Mr. Gurmurthy was asking to withdraw from the case, because those are two different considerations, or whether it's both. And so we've just begun that discussion, just to bring you up to speed here. So Mr. Gurmurthy, you're asking to be withdrawn. Mr. Galt, are you asking for a different appointed counsel as well?
Yeah, well, Your Honor, first time I filed a motion, I was assigned, and this was back in July of 2024. I was assigned a new attorney because Mr. Gurmurthy was never actually. See, what happened is Mr. Seeger assigned himself to my case with a direct conflict of interest. He represented the victim in the case, the victim's boyfriend, the victim's sister, the victim's sister's boyfriend, both of the victim's children. And it took me 5 months, 150 days, before Mr. Seeger was willing to withdraw and acknowledge the conflict issue. So then, since there was a conflict issue, he handed me off to Mr. Thompson. Well, in the process, I got this letter here from Mr. Seeger. Says, I have enclosed a substitution of counsel. If you wish to have alternate counsel, this is your opportunity. And then again on this page, second page, I have enclosed a substitution of counsel. You may execute this form if you no longer wish me to be an attorney. You may. So this was with Michael Horwitz. I said, well, Mr. Seeger, Michael Horwitz, you share an office, so it's still a conflict issue. So he goes, okay, I'll see what I can do. He goes, you have anybody else that you would be interested in? I'm like, well, I talked to Patrick Cherry. He said he'd take the case if you'll appoint him. Mr. Seeger talked to Patrick Cherry. Patrick Cherry said that he wanted $350 an hour. So Mr. Seeger said, well, we ain't paying that. Okay, whatever. So he comes to me and he's like, I talked to Mr. Gurmurthy. He said he'd be willing to take your case. He goes, I'll send you substitution of counsel paperwork, and you can sign and return to my office, and we'll get Mr. Gurmurthy appointed to your case. So he sent me the substitution of counsel paperwork, which I have a copy of here. I got the original back at the cell. I never got a chance to sign it. It's never been signed to send it to me. It's never been ordered by a judge that Mr. Gurmurthy was even appointed to me. as counsel. Okay, so I'm like, you know what, I'm not gonna say nothing, because if things go bad, I can always be like, Mr. Gurumurthy was never actually legally appointed to my case. So that's automatic grounds for an appeal right there.
This isn't about the initial trial where he was found guilty and sentenced. This is about a probation violation. He was given a chance to stay out of jail, and now that he's violated those terms, the court can revoke that probation completely. That means he could now face the maximum sentence allowed by law, which in this case is up to 1 year in jail. And honestly, for what he did, that still doesn't feel like enough.
Well, then Mr. Gurumurthy refused to call any witnesses that I wanted him to call at the preliminary exam. So that's when I was like, you know what? Heck with this, I'm filing a motion to withdraw, or filing a motion for substitution of attorney. So I filed a motion through Mr. Thompson because the case had to get handed to Crawford County because of the conflict issue out of Kalkaska. So I filed a motion and I was appointed a new attorney. Right here, for my August 1st, 6th court date is Shauna Sullivan. Right here, she's an insurance fraud investigative attorney out of Braintree, Massachusetts, that is allowed to practice law in Michigan. So I contact her and she's like, Mr. Galt, I'm not a criminal defense attorney. I'll contact the courts and get this straightened out. So she contacted the courts and I get a second notice for the same court date that says, this hearing will be held via Zoom. Defendant is lodged. Notice resent with no change other than defendant's attorney is now Gurumurthy. So I got appointed a new attorney and reassigned Mr. Gurumurthy. So then we go to the court date on August 6th, Your Honor, Zoom, and I'm in Wexford Jail. And you're like, okay, Mr. Gurumurthy, how's 90 days sound for continuance to file motions? And Mr. Gurumurthy says, your judge, how about 120 days? And you were like, will that be enough time? And he's like, absolutely. So then on December 3rd, 14 months after I was arrested, no motion's been filed. I'm going to use your exact words, Your Honor. Mr. Gurumurthy, you didn't show up today to court. That is unacceptable. Mr. Gurumurthy, you didn't file your motions today. That is unacceptable. That's unacceptable. That's ineffective assistance of counsel. 14 months later, that one motion's been filed on my behalf, and you granted him 120 days to file motions. I've never even got a copy of the motions that were filed. He gave me a rough draft of these motions that had my case and Joe Cunningham's case mixed together. He came to the jail 2 days before court, the court date where the motions were filed on time, to do the corrections. He's like, I'll get you the corrected copies that I'm going to file with courts. I've still never seen a copy of the motions that were filed. I don't know what copies of motions were filed. So then I asked for transcripts, because I wanted transcripts, where you, Your Honor, stated, Mr. Gurumurthy, you not showing up today is unacceptable. You not filing motions on time is unacceptable. I want them transcripts where you, Your Honor, said that, in case it comes to an appeal purpose. And then when we come to the motion hearing on January 24th, you're like, well, I'm not going to have you and Mr. Gurumurthy both arguing motions. I said, all right, well, I'll let Mr. Gurumurthy argue motions. So you're like, Mr. Gurumurthy, do you have anything to say about arguing these motions? Mr. Gurumurthy's like, no, Your Honor, I'm good. Well, if I'd have known he wasn't going to argue them, I would have argued them, Your Honor. You know what I'm saying? So there's another ineffective assistance of counsel.
Now they're about to go over everything he did and said. To the victim, court staff, and probation officers, pay close attention, because what you're about to hear raises a serious question. Was he being intimidating? Was he threatening? Or was this straight-up harassment?
I've begged Gurumurthy to file several motions, and I've got a list of the motions here. I even researched case laws for him for his motions, and he refuses to file motions. He refuses to he refuses to request body cam footage of the search in its entirety. I want officer activity logs. I've got proof with me today of Detective Nichols perjuring himself on the stand under oath. I've got right here
Well, let's try to stay on the lawyer issue, because that's.
Well,
what
this
we're-
is a lawyer issue. This is stuff I'm pursuing. And Mr.
Well, I'm not
Grimwood,
gonna make any
you still
decisions
pursue.
about what police officers did or didn't testify to today. So tell me how that relates to your attorney issue.
Because I've asked Mr. Grimusi to address this with Mr. Ziegler and be like, look, we could discredit your witnesses. We could work some kind of a deal, something. You know, I got my deal from Mr. Ziegler, Your Honor, was on 86 district paperwork with the wrong case number on it from the prosecutor. That was his deal. Another thing is I asked Mr. Grimusi to file a motion, is you know what, Your Honor, felony complaints, citations, anything signed in those are made under oath, sworn to. You gotta be sworn to. I got a felony complaint right here with the paperwork filed from the prosecutor, signed with the complaining witness. It says I committed second-degree homicide on 10/30/2023 in Cold Springs Township. That's 2 days after the defendant was dead. I got a felony complaint right here that says the complaining witness has filed a sworn complaint in this court stating that on a date and location described above, contrary to the law, Mr. Galton, Cold Springs Township, committed second-degree homicide on 10/30/23, 2 days after the defendant was dead. I've asked Mr. Grimusi to file motions to quash charges due to the fact that I was illegally arrested, illegally arraigned on a felony complaint and a felony warrant that contains false information. It was never signed and dated by anybody, the return and tabulation, where I was arrested. I've requested the SIDNET reports, which is an electronic report record for arrest, to find out who even served the arrest record, because I've never seen a felony warrant for 17 months. And I knew that the felony warrant was based off a felony complaint, which was inaccurate. I couldn't do nothing without the actual felony warrant showing that I was illegally arraigned, illegally detained, and illegally arrested based on a complaint and a warrant with false information on it. Okay, this is where it gets good, Your Honor. And I brought this all to Mr. Grimusi's attention. The uniform law citation that was filed to go with the complaint, right here, case number, says nothing about second-degree homicide. In fact, the one that says second-degree homicide was filed on 11/4, 6 days after the defendant was dead, 4 days after I was arraigned, by Sloan Kowalewski, stating that I committed second-degree homicide on 10/27 at 12:00 p.m.
At one point, the judge calls him out perfectly. She points out that he clearly has a problem when things don't go his way, and that kind of behavior shows a childish and entitled mindset. Because, at the end of the day, he's not the only person that matters, and the victim had every right to expect basic respect and safety in public, not to be run over just because someone felt disrespected.
It also says that I was arrested on a warrant on 10/30/2023. Warrants were issued until 11/1. That's false. That's lies in the uniform law citation. Now, this is where it gets good, Your Honor. It says right here, do not write.
I'm not gonna, this isn't I'm not making any decisions on that. I'm not gonna dismiss your case today.
I'm not saying you are, but I need this
You're
all on
going into
record.
argument here on underlying issues. We're just dealing with the lawyer thing. So you think he should have filed motions on these things?
These are issues that I have brought to Mr. Grimusi's
Okay.
attention, and he's failed to file any motions I've requested. And I wanted on record that these are the issues that I've requested the motions to be filed on.
Okay.
You know, these are major issues, Your Honor. They are. This is a murder case. There should be no topographical errors. There should be no misprints. There should be no false statements in felony complaints. There should be no false statements in warrants. Returns and tabulations should all be filed.
Well, I don't know whether they're false or not. I don't know whether they're wrong or not. And I don't know whether that would make any difference. So, again, what we're here on today is the attorney.
So basically,
You're asking for different.
basically, there's been breakdown in attorney-client relationship. Mr. Giramuti has filed a motion to withdraw. I filed a motion for substitution of counsel based on, and this is just a few of them, just a few of the things,
Yeah,
you
okay,
know,
all right, I understand what you're saying.
you know, just,
Um,
I don't know what to do, Your Honor. I'm looking at life in prison,
Well,
and I got a counsel that refuses to file motions.
well, here's the thing, okay, and I'm gonna talk to Mr. Thompson, but one of the concerns I have is it's not gonna matter what attorney I appoint to you, because you're gonna find something wrong with any attorney
No,
that's
I'm not.
appointed to you.
No, no.
Well, because you think that certain things have some significance, and if your lawyer tells you legally you don't have an argument here, or legally these are mistakes, but they don't affect the validity of the charges, you don't agree with that, and so you're gonna be back here again with your next lawyer who refuses to file motions that the lawyer thinks aren't warranted, and you're gonna be telling me the same thing. You understand what I'm saying?
Yeah,
Like,
but
you don't want to hear what your lawyer's saying because you disagree with it, and so you want to keep me, you want me to keep appointing lawyers until you get one that agrees with you,
Well,
and that's not how this works. So that's my concern.
but no, but
When I listen to you talking, that's my concern is I could appoint 10 lawyers for you, and until one does what you want them to do, you're going to claim that they're not representing you effectively
see, this is the
because you're
thing.
not listening to what the lawyers are saying.
Mr. Giramusi doesn't even come and see me, Your Honor.
Okay, well, that's a different issue.
But this is the thing though, is the motions, Mr. Giramuti or whoever is appointed should be willing to file motions on these things.
Well, but that's
And
not
it's up to
true,
you to
though.
rule on them, Your Honor.
Lawyers don't just file everything that their client wants them to file. They have an obligation under the law to only file things that have legal merit. So
And
if you want him to file something, and in his judgment as an attorney, he doesn't think that it has legal merit, he or any other attorney that I appoint for you isn't going to file it. And what I'm hearing you tell me is that you want an attorney that's going to do everything that you want to do. And
No.
that's not
No.
how it works. So that's my concern going forward with you and appointed counsel is that, again, I could go through attorney after attorney after attorney, and we never make it to trial because you can't find one that's going to argue things for you that no attorney thinks has legal merit. So I'm just saying that for the record, that's my concern here.
Here's something interesting that happens in cases like this. Sometimes courts will reduce charges or accept a no contest plea, even when it seems like a guilty plea would make more sense. The reason? It's often done to protect the victim. If the crime is labeled as intentional, insurance companies can deny coverage, which would leave the victim stuck paying medical bills on their own. So while it's not ideal, reducing the charge can actually help ensure the victim gets the financial support they need.
I do want to clear up some things that you said about the succession of attorneys and how we started and where we got. And Mr.
Just
Thompson,
could I
can you-
clarify before Mr.
Yes,
Thompson
Your Honor.
chimes in? Because I can just add a couple of things that Mr. Galt indicated. I think that's important for the record. So Mr. Seeger, I don't know the conversation Mr. Galt and Mr. Seeger had. But when I was,
Well, and I don't want to have you and Mr. Thompson, he's the administrator. I want to hear what Mr. Thompson says. I'll give you a chance,
Okay.
Mr. Gurley.
Thank you.
But I want to hear what Mr. Thompson has to say is going to clear this up or shed some light. So Mr. Thompson, can you tell me what information you have as the administrator of MIDC here?
Yes, Mr. Seeger contacted me. He indicated he was recusing himself from administering this case as well as being an attorney. I appointed Mr. Garamuthi, the court clerk. We've called and confirmed this with the court clerk. Made a typo on the P number, and that's how a lady named Miss Sullivan was identified on a court filing. But Mr. Garamuthi was appointed as attorney. Mr. Galt did request a new attorney through me. I turned him down. At one point, he did appeal. We had that administratively sent to Mr. Slough, the Otsego County Administrator, who issued a written decision also declining to appoint new counsel.
Okay, all right, thank you. Mr. Gabrinki.
And that is where I was just getting at, Judge. So I don't know the conversations Mr. Gall and Mr. Seeger had. Mr. Seeger reached out to me about this matter as conflict for Kalkaska County. In those conversations, and Mr. Seeger may have had those conversations with Mr. Thompson previously or subsequently, I don't know. But one of the discussions was that since Mr. Seeger at the time was grieved by Mr. Galt, it made sense to not have Mr. Seeger on this case only administer the Kalkaska County MIDC administrative duties, and that should go to somebody else. And Mr. Thompson, being the Crawford County Administrator, only took over on this case to administer this matter. Whatever requests and funding or other things that we've had have gone through Mr. Thompson. At one point, I did reach out to Mr. Thompson with Mr. Galt's request for new counsel, because as Mr. Galt indicated, some of the motions that he wanted me to file, I think were frivolous. They weren't with what the law would require. And again, there was when Mr. Galt indicates that a motion to quash was not filed, the court heard arguments that was filed. When Mr. Galt says that motions that he wanted were not filed, we did challenge the search warrant and filed motions to suppress evidence. Those were heard. We had arguments here in court. So I think Mr. Galt is incorrect that no motions were filed. The motions that he wants, that I don't believe legally would have any authority to be filed, were not filed because they're not there. For example, Mr. Galt wants me to file a motion to discredit Detective Nichols. I think that gets done at trial. There's no motion to discredit him prior to a trial. So again, the transcripts that Mr. Galt is requesting, he has those because he has the preliminary exam transcripts. We had a full day, 8-hour preliminary exam in this court, and Mr. Galt was present. So again, some of the things that Mr. Galt indicates are not chronological.
So in reality, he was given everything he's constitutionally entitled to: access to transcripts, the ability to file motions, and even a lawyer to represent him. The only thing he didn't get was his way. And that's clearly the real issue here. Because every time things don't go the way he wants, he lashes out at whoever he decides to blame.
There was that appeal process that went to Mr. Slough. I know Mr. Slough at some point did get involved because I received a subsequent letter from Mr. Slough because Mr. Galt had indicated that he wanted new counsel. I didn't know how Mr. Slough got involved, but I spoke with Mr. Slough and I indicated where my concerns were. But my breakdown comes in after all of those things were done, because certainly Mr. Galt didn't get what he wanted. He didn't get a new counsel. He was turned down by 2 administrators. And I haven't met Mr. Galt in the last 2 weeks, maybe 3 weeks, because I'm not going to take his verbal abuse. I'm not going to sit there and get called derogatory names. I'm not going to deal with his threats. And if I'm going to spend my time meeting with him, it's got to be a productive meeting, not one where I get yelled at, screamed at, called names, and threats being made.
Your Honor.
So at this point,
Second, I'll give you a chance. It's his turn.
I'm
I
sorry.
listen to you. Go ahead.
so when those things happen, I'm not going to waste time and get treated that way. I'm not going to subject myself to that. Mr. Galt is, and I've told this to him, he's not my friend. He's not a family member. He's not a relative. And I'm under no obligation to take his verbal abuse because he doesn't get things done the way he wants or wants, new counsel, whatever his beef is. At one point, he was upset regarding something that happened with his house in landlord-tenant court. Again, there's a limit for me being a punching bag. I've got to deal with this case. This is where I am. But when it gets over that line, I'm not going to deal with Mr. Galt's abuse that way. I'm not going to subject myself to that. I have some self-worth. I'm going to hold myself to that. I've told Mr. Galt that, and Mr. Galt doesn't like that because I stand up to it. Leaving all of those things aside, Mr. Galt has filed a grievance. Mr. Galt has, my understanding, filed a grievance against Mr. Slough and Mr. Thompson.
Never filed one on Mr. Slough.
Mr. Galt's indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I I've just reached a point where I've had a breakdown with Mr. Galt. And then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. You know, I've got kites from Mr. Galt that he indicates he doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are again frivolous, that he's claiming that he's filed and he's done those things. So I've reached a point where there's a breakdown. I will admit to the court, the only things that Mr. Galt does not have is the search warrant body cams, because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive, so I have a copy. There's a laptop at the jail, and then Mr. Galt will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI. And in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and that's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest, and I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me, and I'm just refusing to put up.
What we're seeing here is basically an adult acting like a toddler, someone who clearly doesn't know how to handle being told no. The moment things don't go his way, he loses control and lashes out, instead of dealing with it like a rational person. Now, the lawyer does try to make an argument for stepping away from the case, but it's not exactly strong, and more importantly, it would just slow everything down even further. And because of that, the judge...
All right, Mr. Ziegler, people taking the position.
Your Honor, normally I would leave this kind of thing to the court and to the attorneys, but in this case, this is a case that has been going on for quite some time. Obviously, it's a very serious case. It's a case I would like to get to trial as quickly as possible. I agree with the court's concerns regarding Mr. Galt's behavior. I think it doesn't matter how many attorneys you appoint, and that's evident from the fact that Mr. Seeger had to withdraw, and Mr. Galt grieved him. Now Mr. Gurmurthy is asking to withdraw, and apparently Mr. Galt is grieving him. I have no doubt that if you appoint a new attorney to represent Mr. Galt, that attorney will ask to withdraw. Mr. Galt will grieve him, and we can play this game for however long as Mr. Galt wants to play it or however long as the court wants to entertain it. But at the end of the day, we're going to have a trial on this case. There's no likelihood of any sort of plea resolution. We have a trial set in May. I would prefer to have that trial as opposed to appoint a new attorney, kick the case out 6 months, and then come back here in 6 months on probably similar issues where that attorney is not going to want to file frivolous motions. And Mr. Galt wants that attorney to file. So for those reasons, Your Honor, I don't think the court has to permit Mr. Gurmurthy to withdraw. I'm certainly sympathetic to Mr. Gurmurthy's position here today. I think he had to do what he had to do. He had to file this motion. He had to make his conflicts known to the court. I certainly wouldn't want to be in his position today, Your Honor. But from my perspective, I have a duty to the victims to bring this case to a trial and to a resolution as quickly as possible, and I would oppose any further delays.
Mr. Galt, anything else that you want?
Your Honor, I've never verbally abused Mr. Gurmurthy.
Yeah, I'm pressing X to doubt the validity of that statement.
No, we've had conflicts. Yes, we have. We've argued. Yes, we have. But the things that I've asked Mr. Guramuthi to file motions on are legitimate things. The fact that I never even got a copy of the motions that he files is legitimate. You know, Your Honor, you're the one that told him, this is unacceptable. You didn't show up to court. This is unacceptable. You did not file your motions on time. That was 14 months. Mr. Seeger killed 5 months before he was willing to withdraw because of the conflict issue. I didn't grieve Mr. Seeger for another 6 months after that. So it's not why, the grievance is not why it got handed over to Mr. Thompson. The grievance didn't come for months, 6 months after Mr. Guramuthi was assigned the case. Okay, I mean, I got a search warrant right here that was never signed by a prosecuting official, by a non-attorney magistrate. You know, Mr. Guramuthi fails to be willing to file a motion on these things. Your Honor, you said in court last time we were here that you're not going to have this come back on an appeal. Your own words, Your Honor. So these things are things that are going to make this come back on an appeal. Mr. Guramuthi just got a copy of the body cam footage of the search today. 18 months, Your Honor. And he just got it today. I've been requesting it the whole time. I've been requesting officer activity logs the whole time pertaining to the deactivation of body cam footage. I've researched case laws. I mean, all these things are legitimate motions that should be filed, Your Honor, and you, Your Honor, get to rule on them whether they're frivolous or not. That is your job. These are legitimate things that counsel should be filing motions on as a defense counsel. He works for the state. You know he works for the state. He don't work for me. You know, he's told me several times, I got funding for this, I got funding for that, I got funding for the transcript. I contacted Nicole Hagstrom, the transcriber. She said, I contacted Mr. Guramuthi. He said he'd do what he has to do on his end. We'll get you them transcripts. Nothing. I got a paper right here signed from Mr. Paul South. Said that appointment of substitution of counsel is warranted only by showing of good cause. Good cause may exist when there's a legitimate difference.
I understand that. I don't need you to read that to me. I know what the standard is.
And it stands right here, Paul South. Mr. Guramuthi's filed a motion, said there's been a breakdown in the client, destruction of communication and breakdown in the current attorney-client relationship. I filed several motions. There's been a breakdown in attorney-client relationship beyond repair. Beyond repair. If you send me to trial with Mr. Guramuthi, Your Honor, that's automatic grounds for appeal. You said yourself, you don't want this case to come back on an appeal, and I'm quoting your words over and over again. If you don't want it to come back on an appeal, sign me a counsel that's going to file these legitimate motions.
Okay. All right. You're just starting to say the same things over and over again.
You know, I'm not trying to waste the court's time. I just want proper representation.
Okay. I understand.
And then I'm sorry, in the typo, Mr. Thompson says typo. Your Honor, this is a murder case. There should be not typos. The T should be crossed, the I should be dotted. There should not be wrong dates, wrong addresses. None of it. This is a murder case, Mr. Ziegler. It's a murder case. This stuff should all be checked and double checked and triple checked and quadruple checked before it is even filed.
What you're dealing with here is basically an adult toddler, someone who's never learned how to handle being told no. So the moment things don't go his way, he completely loses control and starts acting out. Now, while the lawyer is trying to make an argument for stepping away from the case, it's not exactly strong. And more importantly, it would just delay the trial even further. And because of that, the judge isn't going to allow it. The case needs to move forward.
The notice right here, let me show you this, Your Honor, before we end this. Right here, Mr. Guramuthi's withdrawal is dated December 9th. December 9th, dating where is it? I got it right here, Your Honor. I'll pull it out of this one. The notice for hearing for today, dated December 9th, 2024, for an April 8th, 2025 court date. That's 4 months ago. This paper right here is grounds for an appeal. You know, Mr. Seeger, 150 days. Here's another 4 months. Mr. Guramuthi didn't represent me. That's 9 months out of the 18, Your Honor. My 180-day rule was violated. My right to a speedy trial was violated just because of these issues. Mr. Ziegler in his motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. You read the motions, Your Honor. I've actually got them right here if you want to go through them again. His motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. There's grounds for appeal. Any case is prolonged for more than 18 months. The people's got to answer for it. By the time I go to court in May, it's going to be 19 months. That's automatic grounds for an appeal. The people are going to have to answer why I wasn't in trial before 18 months.
Okay.
You know what I mean? I'm trying to save the court's time, Your Honor. I just want proper.
At one point, it's mentioned that this is just a police report. But let's be real. There's almost no criminal case that gets fully decided based on just a police report alone. There's always more evidence, more testimony. So that argument doesn't really hold up.
Yeah, okay, all right. First of all, with regard to allowing counsel to withdraw or appointing new counsel, it matters within the discretion of the court. I'm acting within my discretion of ruling on this. First thing I would say, Mr. Galt, is you're free to hire your own attorney at any time that you want. Nobody's forcing you to have court-appointed counsel. So you're free to hire your own attorney. To the extent that you're asking the court to appoint counsel at public expense, there's a process for that. And that process has been followed. And it's resulted in Mr. Gurmurthy being appointed as your attorney. The fact that you filed grievances against him or other attorneys isn't a reason for the court to appoint new counsel. It's not a reason for the court to allow counsel to withdraw. That's been through case law clearly established that defendants are not allowed to delay cases or shop for new attorneys by filing grievances in the hopes of having that attorney disqualified or somehow being required to withdraw. So the grievances aren't a reason. MIDC has addressed your request for new counsel. Under the law, it's clear that the court is to be minimally involved, if at all, in that process. This is the last step, which is the only reason why it's before me, but it's clear that the legislature has determined that the best process is for the court not to be involved because the court's supposed to be impartial and it shouldn't be involved in issues relating to your counsel. So this is only here as a last resort, but MIDC has followed their policy and procedures and they've denied you from receiving new counsel. So the MIDC, through two different administrators, have determined that there isn't good cause for you to be appointed new counsel. I have concerns, as I articulated before, and listening to you, it just reinforces those concerns that it doesn't matter who's appointed to you as your counsel. I'm convinced that you're undertaking a course of conduct here to create appealable issues on your own, and you've admitted it. You're on the record. You told me that you purposely didn't say anything about paperwork that you received and let counsel go forward in the hopes that that's going to create an appealable issue. So I think you're actively, and I want the record to reflect that I think you're actively trying to do things here as part of the pretrial process in hopes of creating appealable issues so that if you are eventually convicted, you'll have a basis to come back. And I think that's important because to the extent that I would find good cause to appoint you different counsel or to have Mr. Gurmurthy withdraw, I think you continue along the same course of conduct with the new attorney. Not only to delay as long as you could in the hopes of getting to the 180-day issue or whatever you perceive to be as issues that could result in a reversal of your conviction later, including delay, including complaining about your counsel, including doing things in your interactions with your counsel. All of that, I'm convinced, is a deliberate course of conduct on your part aimed at creating appeal issues. And I'm not going to allow you to just continue to do that over and over. I think there is not cause here to appoint new counsel because, again, I think the same issue would simply come up over and over again. We did have hearings on the motions that Mr. Gurmurthy felt had legal merit. I agreed that they had legal merit, and I made rulings on those issues, a lot of which involved issues that you're raising here today about affidavits and signatures and those types of things that the court has addressed.
But how about,
Not every mistake, not every typo means that the court has to throw out an entire case against you. So the fact that there are errors, there are minute typographical errors in every case, I would argue. But that doesn't mean that you're just entitled to dismissal of charges because an I didn't get dotted or a T didn't get crossed. So to the extent that you think that's an appealable issue or a reason for your counsel to file a motion to dismiss murder charges against you, which are very serious, I just think you're wrong about that.
I'm not saying that.
The
You
judge
literally
makes it very
just
clear.
said that.
He is
You did
receiving
say
proper
that.
legal
I'm not gonna
representation.
debate. Yeah, I
And if
listened
he's
to you.
not
I
happy
was
with his
very quiet. I
court-appointed
let you
lawyer,
say everything that
he
you wanted
has
to say. Now it's
options.
my turn.
He can
You're
go
gonna
out
keep
and
interrupting
hire his
me.
own attorney
I'm gonna
or
have you
represent
removed
himself
from the room, and I'm gonna
if he
continue.
genuinely believes he can do a better job. But what he can't do is
Again,
complain
I don't
while
think there's good
refusing
cause
to
because I
cooperate
don't
with
think
the
this is a
process.
legitimate. You did say that,
There's
and I'm
nothing-
not going to debate. Yeah, I listened to you.
There's
I was
nothing
very
you-
quiet. I let you say everything that you wanted to say. Now it's my turn. If you're going to keep interrupting me,
Sorry.
I'm going to have you removed from the courtroom, and I'm going to continue to make my record. Again, I don't think there's good cause because I don't think this is a legitimate disagreement between you and counsel. I don't think I don't think you're raising legitimate points. I think this is, again, strategy on your part to try to delay the trial, to create an appealable issue in and of itself, or to create problems with counsel, to create appealable issues. And I'm convinced that, again, to the extent that I would appoint new counsel, we'd be back here in 3 months with the exact same issues. I think Mr. Gurmurthy filed motions on the things that he felt had arguable legal merit. The court made rulings on those motions. So the court is going to deny your request for appointment of new counsel. In terms of Mr. Gurmurthy, your motion to withdraw, I agree with Mr. Ziegler's sentiments that you're not in an enviable position. It's a difficult position to be in. I agree that you don't have to put up with abuse. Mr. Galt, to the extent that you're going to argue with, verbally abuse your lawyer, you're only hurting your own case. And so I would suggest to you, you've got a trial date coming up in May. I would suggest to you that it's in your own best interest to start cooperating with Mr. Gurmurthy, start working with him instead of working against him. But that's up to you. You're going to make that decision. We're going to go forward with trial in May as scheduled. Mr. Gurmurthy, the court's denying your motion to withdraw for the same reasons that I'm not allowing new appointed counsel. And the only thing I would say, Mr. Gurmurthy, is to the extent that Mr. Galt doesn't want to cooperate with you, to the extent that he engages in abusive verbally conduct with you, arguing with you, he's only doing that at his own risk. And again, I'm sorry that you're in that position, but I think that's where we're at. So, and Mr. Galt falls in your court as to whether you want to work with your attorney. But we're going to proceed with trial as scheduled in May. Mr. Gurmurthy, I just request that you prepare an order that reflects the court's ruling today. Submit that under the 7-day rule.
I was just going to send it to Mr. Ziegler for approval. It was submitted. Normally, we're good with communicating them, so I used to do that.
That's fine.
Your Honor,
Yep.
does it matter that this was never, his appointment was never consented by me and never ordered by a judge?
I guess that's something you can bring up on appeal if you're.
Okay. And the fact that Mr. Gurmurthy has admitted that there's attorney-client breakdown beyond repair?
I don't know that he's done that.
He did. It's in his motion.
So here's the spoiler. He does end up getting convicted, but not through a full trial in front of a jury. Instead, it happens through his own plea. What this means is that after this first hearing, there was another hearing, which isn't available here, where he accepted a plea deal and entered a no contest plea. And the charges? Second-degree murder of his girlfriend, which makes this situation even more disturbing, especially considering the complicated and messy relationships involved. Now, in the next part of this case, his sentencing, you'll see him suddenly try to backtrack and claim he wants to go to trial instead. But let's be honest, this isn't about justice. It's just another delay tactic. And the judge sees right through it and isn't going to entertain these games.
Record in People versus Richard Galt, file number 244943. If I can have counsel put your appearances on, please.
Your Honor, Ryan Ziegler on behalf of the people.
The yellow Reviger Murthy on behalf of Mr. Galt, who's just seated to my left.
Thank you. This is the date and time set for sentencing hearing. The record should reflect Mr. Galt's present here in the courtroom today. Mr. Galt, have you had a chance to go through the pre-sentence report and talk to Mr. Germerke about that?
Judge, Mr. Galt indicates he's having a hard time hearing. I know in the past he's had headphones, and I didn't see any here, but.
All right, I'll make sure that I speak up.
Right.
Mr. Galt, did you have a chance to go through the pre-sentence report with your attorney today?
Yes, sir.
Okay.
Your Honor, I want to withdraw my plea.
Okay. What's your basis for that?
Well, Your Honor, will you bear with me for a minute, please? The 14th Amendment of the United States Constitution provides no person shall be deprived of life, liberty, limb, or property without due process of law. Okay. Now, I'm sure, Your Honor, that you're familiar with the great liberality standard. The United States Supreme Court in People versus Benchek, 360 Michigan 430104 NW 2D 191. The Supreme Court in Benchek Supra, page 432, stated, generally, it is considered that there is no absolute right to withdrawal of a plea. But this court's decision suggests that the trial judge's discretion be exercised with great liberality when the motion is made prior to sentence or commencement of trial. I have a motion here with me today, Your Honor. The same great liberality standard is to be applied when the request is to withdraw a plea of guilty or no contender plea. The Benchek and Prodigy are founded on the premise that the right to a jury trial is so important that exercise of that right should not be impeded by belief in the defendant's guilt. Okay. Under Michigan Court Rule 6.310, withdrawal or vacation of plea, B, withdrawal after acceptance but before sentence. Number one, a plea may be withdrawn on defendant's motion or with the defendant's consent only in the interest of justice. In People versus Bonneville 291, Michigan App 363, 376, 804 NW2D 879, and Bonneville 291, Michigan App at 377 states the following. A motion to withdraw a plea before sentencing should only be granted if the defendant is able to show that withdrawal of the plea is in the interest of justice, meaning the defendant has to articulate a fair and just reason for withdrawing the plea. Fair and just reasons are an actual claim of innocence or a valid defense of the charge. Your Honor, I'm innocent. My valid defense of the charge is I have DNA results from 2 different forensics labs of Jessica's fingernail clippings that say there was multiple contributors to DNA found under her fingernails, but there was no match to my DNA. Again, there was no match to my DNA under her fingernails. I have the Verizon Wireless report showing cell phone coordinates proving that the descendant and I were in different counties when the 911 call was placed. The Verizon Wireless report also proves that the prosecution can't even place the descendant and I in the same county as each other for the days in question. That's right, Your Honor. The Verizon reports don't even put the descendant and I in the same county for the days the crime was taking place. I have the Verizon reports with me today. I have the DNA reports today with me for your review. I have medical reports with me today. Okay.
Now here's something important to understand about plea deals. A judge has full authority to either accept or reject a plea agreement. This isn't unusual. It happens all the time in courtrooms. But there's a key difference here. Just because a judge can accept or reject a plea doesn't mean they're involved in negotiating it. That process happens between the defense and the prosecution. The judge's role is simply to review it and decide whether it's appropriate and fair under the law.
Mr. Galt, we had a trial. We had jurors. We were ready to go. Right?
I asked for a continuance to hire my own attorney, Your Honor, and you denied me a continuance.
Right. So we were ready to go to a trial. We had jurors here ready to hear your evidence that you have here with you today.
Your Honor.
You waived your right to that and you entered a plea on that day. So why should I now allow you to withdraw that plea?
Well, Your Honor, for several reasons. Okay. I filed 4 motions for substitutes of attorney that were denied. Mr. Guramuthi filed a motion and terminated his attorney-client
I
relationship
know all of that.
2 months before trial.
That's not a reason for me to allow you to withdraw your plea. You knew all of that at the time you entered your plea.
A legitimate claim of innocence and a legitimate defense to the crime is reasons to allow me to withdraw my plea.
It's also reasons for you to go to the trial that we had ready and set with jurors here ready to go that morning.
With an attorney that terminated his relationship with me, and we didn't prepare for trial, Your Honor.
You had plenty of opportunity. I'm not going to argue with you. You waived your right to that jury trial and your right to present all of that evidence that morning on the record. Right? I explained all your rights that morning, didn't I?
Can I finish reading this?
Didn't I explain all your rights that morning?
Yes.
Yeah. And you said you understood them?
I've
Right.
never signed an advice of rights form in relation.
You stated on the record that you understood your rights, did you not?
Your Honor, I never signed an advice of rights.
That's
form
not
in
my
relation
question.
to this case.
That's not my question. My question is, you stated for the record that you understood all your rights, didn't you?
Your Honor, I have with me
Okay.
today medical reports that shows that Jessica died from internal bleeding due to cirrhosis of the liver. I have the medical reports right here with me
Okay.
for the family.
You,
I can
you
show
had,
the
you
family
had
the
your
medical
opportunity to present all of that to a jury, and you declined that opportunity. You accepted a plea. Under the court rule that you cited, which is correct, NCR 6.310, you need to show that there was some type of error in the plea taking process. The plea taking process. That means what we did on the record that morning in taking the plea. So I need you to tell me what you think the error was in the plea taking process.
Well, Your Honor, I believe the error was the fact that you participated personally in the plea negotiations with my attorney and the prosecutor in the judge's chambers.
Okay. How was
According
that?
to
How was
People
that?
versus Green, People versus Cobb, and People versus Killebrew. It says, we hold that sentencing concerns are appropriate subjects for plea bargaining. However, we hold that judges' roles in plea negotiations, and sentence bargaining included, is limited to consideration of the bargain between the defendant and the prosecutor. The judge may not become involved in the negotiations. Due to the nature of unequal bargaining positions of the judge and the defendant, any involvement in the negotiations transforms discussions into perceived coercion.
Yeah, I was not involved in the plea discussions.
Mr. Guramuthi told me that you,
I asked the attorneys whether there was a plea agreement, and they indicated to me that you wished to enter into a plea agreement, which you confirmed on the record.
Mr. Guramuthi told me that you were willing to allow me to make a plea of no contest to second-degree murder, a plea offer that was taken off the table 2 months prior. I was told that the judge is not going to allow you a continuance to hire your own attorney, but he has agreed to allow you to plead no contest to the second-degree murder plea agreement that was taken off the table 2 months prior.
And that's what we put on the record that morning.
Right, that you were involved.
At this point, the court is questioning why his evidence should even be considered during sentencing, especially when earlier he was ready to accept a no contest plea, which would have avoided dragging the victim's family through even more pain. Because let's be honest, they've already suffered enough. Reopening everything again would only make things worse for them, bringing back trauma they're still trying to cope with.
Is that your only error that you're claiming in the plea process?
Other than the fact, Your Honor, that I have a legitimate claim of innocence
Okay.
and a legitimate, I am innocent and I have a valid defense to the charge.
Okay.
I have the
Right.
DNA results.
All
I
right.
have the
Thank you.
Verizon
You've
wireless
stated your
report.
basis. I appreciate that. Mr. Grimmer, is there any other legal argument you'd like to make on Mr. Galt's behalf?
Regarding the withdrawal of plea, no, Judge. I've done my research. I've indicated to Mr. Galt, under the court rule, there was no legal error in taking of the plea. I've indicated to Mr. Galt, the court was not involved in plea negotiations. Mr. Ziegler, the morning of trial, and the jurors were here, renewed a plea offer that Mr. Gall then accepted. That's the process of what occurred. And then we did ask the court if the court would allow Mr. Gall to enter a plea and release the jurors if he entered a plea. In my experience, once the jurors are here, this court has not allowed that to happen, and essentially, at all plea cutoffs, essentially has treated that as a plea cutoff. And that certainly was not the case in this matter, because the court did allow, based on the renewal of the plea offer from Mr. Ziegler's office.
Correct. Okay, that's correct. Mr. Ziegler, any response to people on the defendant's motion?
Just two things, Your Honor. As to what Mr. Gurmurthy just said, I would confirm for the record that the plea offer has been the same pretty much since the inception of this case. The court was not involved in any negotiation or amendments to the plea offer. The offer in this case has been and has always been for over a year, at least closer to a year and a half, murder second. So there was no court involvement in the negotiation, just that the court allowed us to take the plea in spite of the fact that there was a plea cutoff prior. In terms of the actual innocence argument, Your Honor, I don't have any of these Verizon reports the defendant is claiming to want to present. I don't have these independent reports that Ms. Scott died of cirrhosis of the liver. Those are not the reports that were provided to me by Mr. Gurmurthy. It's the first I'm hearing of them. I don't believe they either exist or that they say what Mr. Galt implies they say, but in any event, I agree with the court. If he wanted to present that evidence, we had a trial date ready to go. He understood that. He chose to plea. There's no palpable error in the plea taking process. There's no interest of justice that would allow the withdrawal. And certainly I would further argue under 6.310B that the prosecution would be prejudiced by a withdrawal of that plea, as it took significant time and effort to prepare for that trial, which was going to span over 2 weeks and involved subpoenaing and coordinating over 30 or 35 witnesses on the prosecution side to appear and to testify at that trial. Certainly allowing the defendant to withdraw the plea at this stage based on what the defendant has argued would create some prejudice to the people's side. So for those reasons, Your Honor, we'd ask the court deny the defendant's motion.
And Judge, I should make the record just clear that the only reports that I have, and I don't know what report Mr. Galt is indicating he has independent of what we have, is the defense's expert. That's the report. Then Mr. Ziegler has that report.
I have the medical.
Look, I'm not getting into evidentiary issues here today. This is way outside the scope of what the court would consider on a motion to withdraw a plea. So I appreciate your position, Mr. Gurmurthy. I'm not going to go further down this road because I view it as a waste of time at this state. I'm not going to allow Mr. Galt to continue to waste the court and everybody else's time with arguments that are.
Things take another turn when the defendant is actually removed from the courtroom. Why? Because he wanted the family to believe that the victim died from liver cirrhosis, not from the injuries he caused. And after he's taken out, the judge addresses the family directly. She explains that while their emotions are completely understandable, certain reactions in the courtroom could potentially create issues later, like giving the defense grounds to challenge the sentencing on appeal.
Under MCR 6.310B, the court can allow, and I view that as B1, I view that this as a permissive type of situation where the court can allow in its discretion the defendant to withdraw a plea where it's in the interest of justice, and a claim of innocence certainly could qualify for that. I think it's clearly contemplated under those circumstances that where a defendant enters a plea and then makes a claim of actual innocence later, it's because of some type of new evidence that was discovered or some type of new circumstance that arose between the plea and the sentencing hearing. That then creates a question as to guilt or innocence and would allow the court to allow the defendant to withdraw the plea at that point, or some other type of situation such as fraud, duress, some other undue pressure brought to bear in the plea process or negotiations that in the interest of justice would require to withdraw the plea. I'm not hearing any of that today, other than Mr. Galt's continued claims of innocence, which again, he had full and fair opportunity with the jury present to present those to a jury on the day of trial. and he chose on that date to enter the plea. And nothing has occurred in the interim, which convinces the court that he is actually innocent, or that it would be otherwise in the interest of justice to allow him to withdraw the plea. At this point, even if that were the case, for the reasons stated by Mr. Ziegler, there would be a high degree of prejudice to the people in allowing you to withdraw your plea at this late state when they were prepared, had all their witnesses ready to go for trial, and only because of your decision to accept the plea on that date did they not present those witnesses and that evidence and testimony. So for those reasons, to the extent it's within the discretion of the court finds that it should not exercise the discretion and allow you to withdraw your plea. The only other circumstances where you would have a right to withdraw your plea under 3.10B2 involves sentencing agreements or consecutive sentences. None of those are applicable in this case, with leaving the only other possible option as an error in the plea proceeding. I rewatched the plea hearing and all the proceedings and reviewed the transcripts in preparation for the sentencing hearing today. There wasn't anything, in my view, that either court or counsel did in the proceeding from a procedural standpoint in the taking of the plea on the morning of trial. An appellate court may someday disagree with me and find an error that I'm not seeing, but from my view, there was no procedural error in the taking of that plea. I'm convinced, Mr. Galt, that you were fully aware of what you were doing on that morning, that you were voluntarily and knowingly entering into that plea. I view your motion here today as a continuation of the strategy that you've employed throughout this case, which is to simply try to prolong things, to backtrack, to do everything that you can to prevent a final resolution in this case. And I view this motion as having really no merit and just another attempt on your part, just as demanding to go to trial, getting everybody prepared for trial, and then on the morning of trial deciding you want to enter a plea, now reversing your course on that. I don't find any valid legal argument. And again, I think it's a strategy on your part to try and create errors in this process for later for appellate purposes, or to try and delay it. So for those reasons, your motion is denied. The court is going to proceed with sentencing. Mr. Kermurthy, are there any additions, deletions, or corrections to the pre-sentence report?
Can I just put one more thing?
No, you
on record?
cannot. I'm sorry, I'm done.
Like, I need to establish a record, John.
I'm sorry, I'm not going to allow you to do that. I've allowed you to state what you're going to state today. We're proceeding with the sentencing hearing. If you're going to continue to interrupt me during the process of this proceeding, they may have you removed and you can watch it on video. If you want to remain in the
Due to
courtroom,
my current
you remain
medications
quiet.
I'm on, I'm unable to make a spare of the moment logical decision first thing in the morning due to my medications. And I think it's in the interest of
I'm sorry.
justice
I'm
for
sorry.
the family to be able to see the
I'm
medical
sorry.
reports and the DNA results.
Sorry,
and the
we're
private
not doing
reports.
any of that today. We're proceeding with sentencing today. I'm going to give you one more opportunity to cooperate with the proceedings. If you don't, again, I'll make a decision about whether you need to be removed or not.
Quit looking at us, motherfucker.
All right. Let's take a break. Let's remove Mr. Dalton from the courtroom for a minute.
In the end, he's sentenced to decades behind bars, time that he'll have to spend thinking about the damage he's caused. And while some might hope he reflects and learns something from all of this, realistically, that's not always how it plays out. What matters most is that justice was served, and he's no longer a threat to others.
So, ladies and gentlemen, and I want to make the record clear, defendant's not in the courtroom at this time. Ladies and gentlemen, I understand this is a difficult situation for all of you, and I understand the need and the desire and the inclination to want to respond to things that Mr. Galt is saying here in the courtroom today. And again, it's totally understandable. I can see where you're coming from, but it's really important that this hearing is carried on in a business-like way. And really, it's in your own best interest to ensure that Mr. Galt's sentence is upheld later, and interruptions and problems here in the courtroom are only going to complicate that. So you're not going to be helping your own positions in ensuring that Mr. Galt is sentenced and stays sentenced if there are problems here in the court during this hearing. So I'm going to ask that all of you please try to refrain from making any comments to him, having reactions to things that he says or does, and directing any comments or any outbursts towards him during the course of this hearing. Again, it's going to impede my ability to do what I need to do, what the court needs to do. It's going to impede my ability to make sure that Mr. Galt, that his sentence sticks later. If there are any of you that feel that you can't do that, and again, I understand that, I'm going to ask you to leave the courtroom, to have an opportunity to view the proceedings later if you want to do that. But again, if you don't feel like you can refrain from making comments or having outbursts here in the courtroom, I'm going to ask you to leave. Other than that, we're going to try and proceed again. If you can bring Mr. Galt out, please. Everyone, be seated. Thank you. Mr. Gurmurthy, anything on behalf of Mr. Galt?
Does Mr. Galt, in lieu of preserving his rights, has asked me not to allocute on his behalf, so I don't have anything to add or allocute on his behalf.
Mr. Galt, is there anything that you wanted to say? The record should reflect Mr. Galt is shaking his head no. I obviously had an opportunity to review the pre-sentence report. We've had a lot of different motions in this case reviewed, as I indicated earlier during this hearing. The transcripts from the preliminary exam was part of the plea process, but I reviewed it as well as part of my consideration in sentencing. I've reviewed the file. Obviously, I've reviewed the pre-sentence report, which gives a very detailed account of the relevant facts in this case, and also provides a lot of information about you and your background, Mr. Galt, your history, and so forth. I do want to thank Ms. Yeomans for making a statement that she made here today. I always think it's important for victims to stand up and make a public statement, as difficult as that can be, especially under these types of circumstances. Number one, I think it's important for the court and the public to hear it. And number two, I think it's important for other victims to hear when they see someone have the courage to stand up and make a public statement about how crime has affected them. So I appreciate your comments and the letter that was written and the other individuals that have appeared on behalf of the victim in this case. The prosecutors talked a lot about the aggravating factors here, and I don't think I need to go through those again. I don't think certainly the victim's family doesn't need to hear about it again. You're well aware of your conduct, Mr. Galt, and what you did to contribute to the death of Ms. Scott in this case. A judge that I respect and admire and has been a mentor to me once told me that the more heinous a crime is, the less a judge has to say at sentencing, because it's self-evident the effect that it's had and the degree of depravity that has occurred. And I think the facts as laid out by Mr. Ziegler during his allocution clearly established that. I also think from the standpoint of rehabilitation, your record is an absolute indicator to me that there is no possibility for your rehabilitation, Mr. Galt. You have engaged in this type of abusive conduct towards other individuals and towards your domestic partners, as Mr. Ziegler indicated, for over 20 years. I counted 6 prior domestic violence convictions and 5 prior assault and battery convictions. You've had 10 prior jail sentences, 2 prior prison sentences. You've been on probation for 8 times in your 56 years. That to me indicates a long pattern, a long history of engaging in the same conduct over and over again towards different partners. I fully agree with what Mr. Ziegler had to say in the sense that this unfortunately was the last individual that you had an opportunity to have access to and to abuse. And this, I think, could have happened to any of your prior partners. It happened to go too far in this case, but I think it could have happened in any of those other cases, and they're all probably lucky that it didn't. Unfortunately for Ms. Scott, she was not. I'm fully convinced that if you were ever to be released and engage in another domestic relationship, you would engage in this exact same conduct. And for those reasons, for the safety of the public, the safety of the community, I do think that a prison sentence at the top of the guidelines is absolutely appropriate. I think it's important that you're never allowed to have access to another individual again, that you have the opportunity to abuse in the way that you abused Ms. Scott and the other women that you've been involved with throughout your life. So for all those reasons, the court finds, again, that a sentence at the top of the guidelines is appropriate. The court will sentence you to 450 months. That's 37.5 years to 60 years in the Michigan Department of Corrections. You do have credit for 617 days served. There will be a crime victims assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost.
All right, guys, that's the end of this video. This one was definitely a tough watch, but we made it through. If you found the video interesting, make sure to hit the like button. If not, that's fine too, but let me know your thoughts in the comments. And don't forget to subscribe with notifications on so you don't miss any future videos.